Ready? Start. Two tests have been laid down, one being the legitimacy of the expectation and second being denial of legitimate expectation that led to violation of Article 14. Stop. When the facts of the case are examined in the light of the enunciation of law, in the aforesaid judgment of the Constitution bench of this court, may be, at the cost of petition, we need to add that in the case in hand, the past practice was merely on the basis of the situation at the relevant time when there were only 20 seats for imparting education for Ayurvedic Nursing Training Course and only one government institution was authorized to conduct the course. Stop para. Since there were more vacancies, most of them may have been adjusted. Stop. However, subsequently there was change in the policy as number of private institutions were permitted to impart education for the Ayurvedic Nursing Training Course. Stop. It is also on record that there were no appointments made by following the earlier system available after 15/12/2014, except few, as is evident the later dated 28/3/2015. Stop. It is evident therefrom that only the candidates who were admitted till the year 2010-11 were given appointment, and that too due to court order. Stop. Statutory rules governing the post had not been framed earlier, and the same came to be framed in the year 2021. Stop. There was change in the process of selection as well, namely, earlier the selection was being made by UPSC, now it was being made by UPPSC. Stop. Further, after the change in policy of the government permitting private institutions to impart training for Ayurvedic Nursing Training Course, the availability of candidates was much more as compared to the earlier regime, where only 20 seats in the government institution were here. Stop para. The available vacancies with the government being less, the normal rule provides for a selection process to be followed so that the best available candidate is selected. Stop. There is no violation of Article 14 as, in the facts of this case, it cannot be opined that there was any discrimination against the respondents or that the action of the state was arbitrary. Stop. Para. The essence of discrimination is the unequal treatment of equals, however, the state has clearly established that no appointments were made under the old system for any candidate admitted after the 2010-11 session. Stop. Since no batch mates of the respondents, nor any other candidates passing out after the first private college batch in 2016, were given direct appointments, there is no instance of a similarly situated person being treated preferentially